Okay, 2:15. Let's carry on. Where did we get to on the question of any questions to do with SANGs or similar?
Yes, I've got a few questions. I don't think there's any objection.
So there's no objection. Obviously, Mr. Jack, if it's something to do with the interpretation of policy, or it's something that he can defer to Mr. Collins, and that will be a sensible way of dealing with any issue.
No, that's helpful. It makes sense to air them now. We'll see where we get to. Okay, so I think before turning to Mr. Brown, let's deal with those questions, Mr. Cosgrove.
Thank you, sir, and good afternoon, Mr. Jack. Can I just have you got a copy of this? It's NID document 13.2. It's one of the recent ones, and that's the trail of correspondence with Natural England about SANG and other issues. Do you have access to that? I mean, I know this morning it hadn't made it onto the council's website, but I suspect you may have your own copy.
Sorry, what was it?
So it's under the weird numbering system of this inquiry. It's NID 13.20. So it's a series of correspondence to and from your client and the Natural England, or Mr. Kite and Natural England, I think.
Is it, and it's different essentially from the
Well, it's got one that isn't in Mr. Kite's. It's got the more recent one. It's got one dated April, so I thought it would just bring us up to date.
Is that the email April the 7th?
It's on.
Exactly.
I've got that email.
Oh, all right, thank you. And I think yes, and you help me. What it does actually, it also has all the other emails that are also a Mr. Kite statement as well. So it's a convenient place just to have all. Okay, first, great. So that's 7th of April 2025 email. I think it's the latest response from Natural England, isn't it, to Mr. Kite. Now, just a few questions. As I say, if I'm straying into others' territory, just let me know. If we look at Mr. Kite's statement, which is appended to your evidence, could you go within that to section 4? If you're looking at it electronically, it's PDF or electronic page 45 of 91, and it's got a little subheading. The proposed expansion of the SANG to 12 hectares. Do you see that? So do you have that?
Yep, got it.
Thank you. Now you say as mentioned above, the appellants team is engaged with Natural England. It says includes various meetings, and the purpose of it is this is in relation to the increase to 12 hectares, and I think there's some amendments to the 106 to try and secure that. In that context, which it said here at 4.6 would increase its driving catchment for visitors 4 kilometres and enable it to have an even greater role in facilitating future residential development sought for Hazelmere area under LPP2. That's the second part of the plan. So that's the purpose of the 12 hectares, as I understand it. Yeah, okay. Thank you. Now, again, if this is an issue, I don't think it's an issue, but when the local plan part 1, when the inspector looked at that and that was made, it was not at that stage found necessary for there to be a strategic SANG, was there?
Yeah, that might be something.
That's not your fine. Okay, that's fine. And the only reason I ask is and I'll read it out to you, is what the inspector said, or the inspector's report says, due to the amount of natural green space in the area, SANG is not the only potential mitigation measure, and there's no need for a strategic SANG. But I can deal with Mr. Collins with that. But that's why I'm going to put to you as a part of the context. When we get to LPP2, and again, this is referred to in Mr. Kite's statement, there's reference to para 7.14 of LPP2, which is where the various thresholds are set out. And we can go to that. Would you like to go to that, or are you familiar with them? Yeah, you're familiar with it. And just to remind the inspector, so for sites between 400 and 5 kilometres of the Wealdon Heath SPA, a project level HRA may be required, it says. And then Natural England has advised that all net new residential development between 400 metres and 5 kilometres of the SPA, the following should apply. So we've got 3 thresholds: less than 20 dwellings, unlikely to need mitigation. 20 to 49 dwellings may require some form of mitigation, such as heathland infrastructure projects and associated appropriate assessment for any planning application. And then thirdly, 50 dwellings and more may require a SANG and an associated appropriate assessment for the application. So those are the policy thresholds which apply in terms of the development plan. Now, in terms of Mr. Kite's statement, when we're looking at where we are, so 4.6, if you go down to 4.9, he says, as shown in map 2, which you've taken to, you've got your areas, and he said that would encompass, increase to 4 kilometres would encompass a total of 9682 existing residential delivery points, as well as the following additional LPP2 allocated sites. Now, it's right, just the first point, so far as the inspectors got their thresholds, unless you're a site of 50 dwellings or more, so far as the development plan is concerned, you're not, on the face of it, going to need a SANG, are you?
That's great.
Great. Second point is, I mean, again, if you don't know, are you aware of how many allocations, in fact, in the whole of the district might require a SANG under those thresholds?
I'm not.
No. Okay. Well, I'll put it to. Again, I'll deal with that, Mr. Collins. I think it's only 2, and one of them is the Royal Junior School site, which again Mr. Kite mentions, and I'll come back to that in a minute. The other one was a site called Secrets, which the last inquiry looked at. The inspector may have a vague memory of the last inspector's decision dealing with, which has subsequently got planning permission and a SANG. Do you know about that one or not? Land at Secrets in Milford, permission for 216 dwellings with a SANG provided for it. No, okay, fine. So, so far as the Royal Junior site is concerned, which I think is also one of the sites we're looking at with Mr. Collins, but are you aware of the latest proposals in relation to SANG on that site?
It's in detail.
No, okay. I'll tell you what we're going to say, and I'm going to tell Mr. Collins, just as far as it's saying that there is a proposed SANG solution, which doesn't involve relying on Scotland, your scheme. It involves, I think, an on-site solution proposed. But if you're not aware of that, we won't go any further.
I don't think I've seen the detail. But
Fine. All right, I won't ask you any more about that. I'll leave that to Mr. Collins. I just wanted to check you were not the man to ask about that. Good. Then, so in terms of the allocated sites within and around Hazelmere, on the face of it, apart from on that looking at that list at 4.9, the other two, well, the first 2 bullet points is an asterisk in Mr. Kite's statement. They've got planning permission already, I think. So far as the other ones are concerned, just on the face of it, they're not within the thresholds that would require a SANG, are they? Because they're not 50 or more. Is that right?
That's correct.
Yeah. Okay. Now, just going to the 13.20, the Natural England correspondence, Mr. Kite was sort of doggedly pursuing them and getting propositions. You can see the latest one, the most recent one, just to bring it up to date, the 7th of April 2025. In relation to the bottom of the third question, they're asked, is Natural England currently aware of any other strategic SANG or similar mitigation coming forward in Hazelmere? And they say, correct, we're not aware of any. Under the adopted plan, and they refer to LPP1 and LPP2, which I've just referred you to. Site allocations are included in that, where the provision of mitigation towards the SPA is expected for those that meet the relevant dwelling thresholds. As far as you're aware, the thresholds are the ones we've just talked about in LPP2. Yeah. All right, thank you. And then just, if you go to that, it may be easier to do it in this document, that most recent, the one you looked at, Mr. Kite's statement, which is their response of 7th of March. Remember the first query, second query, and so on. So it's actually within NID 13.20 if one tracks back, or in Mr. Kite's statement. It's right, you point out, or Mr. Kite points out, that they accept the potential benefit of additional SANG to 12 hectares. The council doesn't disagree with that. But viewed in context, it's right to notice that the Natural England still make clear, don't they, both in relation to the first query and the second query, that they have still maintain objections overall to the scheme.
Yes, non-HRA related objections.
Yeah. Okay, good. Thank you. I think those are the only questions I need. Thank you for bearing with me. Thank you, sir.
Okay, thanks very much. So, Mr. Brown, over to you.
Thank you very much. Good afternoon. Mr. Cosgrove's just killed our first question. He's repeated the same as we did for the document on the 7th of March, that Natural England still object to the application. Yes, so I'll skip over that now. Our second question is respect to the Surrey Wildlife Trust letter. In the last paragraph, page 1, they state that it is only valid for a year. Yes, agreed? As we now have phase one with more than 50 homes nearing completion on the land directly adjacent, do you agree that this will have an impact on the proposed site?
Could you expand on that a bit, please?
The Surrey Wildlife Trust assessment, when it was done, didn't include phase one or any of the building in phase one. Now phase one's nearly completing. Most of the wildlife has moved on sidewards down into phase two and local gardens. So would you agree that this phase one will have an impact on the Surrey Wildlife Trust assessment?
Surrey Wildlife Trust, the consultee really, and the assessment obviously has been done by the appellant ecologists. Is that what you mean? Or do you mean that the Wildlife Trust's?
The Wildlife Trust assessment, as it is, because it's over a year old, the housing has changed, or the land has changed from phase one, which leads directly to phase two. So surely the validity of the 1 year is very valid, because you should be now reassessing the assessments that Surrey Wildlife Trust made. Yes?
Yeah, I'm not totally comfortable with the word assessment, because again, it's a
Oh, consultation, sorry, yes, okay.
Yeah. No, I think that's probably a bit of a stretch, and obviously the council hasn't felt the need for an updated
So the answer is no.
position statement. And yes, and as I mentioned earlier, they've taken that position statement, that agreed position statement, and that's now the basis for the statement of common ground.
Okay, thank you. Note all that. And you mentioned you did a walkthrough. Did you document those changes? And again, do you agree that any decision would require an updated Surrey Wildlife Trust consultation?
Because of the construction progress.
And you've done a walkabout, but we haven't seen any documentation of whether you agree that there's any changes.
It is in my proof of evidence.
Is it?
Briefly, yeah, strongly aligned.
Is that possible to refer to? Because I couldn't find it, if that's
Yeah.
okay.
So it's 2.4 into 2.5 of my main proof. So 2.4 describes the walkover, and then 2.5 gives my opinion. The scope of the assessment work done between 2018 and 25 is sufficient to enable a clear and current picture to be built of the ecological baseline, and therefore form a robust ECIA.
Let me just have a quick look. Okay, right. I don't actually agree fully with that, but okay, fine. Thank you. And just,
it's addressed in my rebuttal as well, if that's helpful. 2.72 again mentions the walkover. It says that in order to confirm that the findings of the assessment programme continue to hold true.
okay, so
Which paragraph was that in the rebuttal?
2.72.
oh, 2.72, sorry, I didn't get that. I'll just have a quick read, sorry. 2.72 in the rebuttal. No, we haven't got that one open, sorry. You'd say then it continue to hold true then? Yeah, okay, thank you. And last question on the biodiversity audit of Hazelmere's ecological network, CD 7.54. That's that one. Earlier we were talking about the corridors and the statements of the north-south corridors. We just need to clarify that all north-south corridors on the maps on page 26, 27, that's maps 8 and into 9, are relevant as these take wildlife over the site, out of other corridors, leading to areas to the east of all the other sites. Do you agree that connectivity of north-south corridors with the east-west are important?
So bear with me. Maps 8 and 9, was it? Or
Map 8 and 9 on page 25, real, I don't know what that is in. Oh, 26, sorry. 26 or 28. We're just trying to ascertain the relevance of all of the north-south corridors. Because we focused on, or you focused on the ones on the Midhurst Road, whereas there are many other north-south corridors.
right. Well, I think I was referring to the corridors in the immediate vicinity of the appeal site, which go north either into central.
Sorry, can you put your microphone a bit closer? I couldn't
Okay.
quite hear what you're saying, sorry.
Leaning further and further back.
That's all right, sorry, thank you.
I was referring specifically to the corridors immediately in the vicinity of the appeal site.
So you're relating just to the one on the Midhurst Road, but you agree that all the other north-souths are important connectivity points for going east-west over the map into the next page and out into the end of Scotland's Lane and up into...
I think for me, again, I think I reiterate my view, they generally of less potential importance. So the two corridors that go through Redcross do just join up with residential curtilage vegetation on the settlement boundary. So I
They
think
go north and south and right down into Valewood, is it down there? Yeah. Down to the South Downs National Park.
yes, I suppose it's the northward direction of connectivity that I'm suggesting has a more moderate level of
So
value.
you're just saying the north one going up into town isn't so important, but all the others are still very relevant as connectivity points?
Well, no, not exclusively. No, I think I again, I think I sort of stand by what I said.
Yes, going north and south. Yes, so that's what we just agreed. Yes, okay. No, that's fine. Thank you. And that's all my questions. Thank you. No, I haven't got it. Oh, well, can you hold line just for a sec? Yeah, can we just bring up the Midhurst Road one again? Sorry, because it's very relevant. I refer you to the tree retention and removal plan in NID 8.5. It's in the maps we handed out this morning. Looking at where the trees will be removed from the western corridor along the Midhurst Road, i.e. the red area. Dry. Can you confirm that the area to be removed appears to be at about 1/3 of the corridor?
Sorry, I'm not trying to antagonise you, but I've not managed to get it open yet.
That's right, sorry. So I struggle as well, don't I? We have a hard copy here, actually, if that would help. Nope. Oh, there we are. Oh, all right, found one. Thank you. Lots of them now. Just go back there. Okay, so just going back over from where we're looking at the trees, which will be removed along the western corridor along the Midhurst Road, i.e. the red area. Can you confirm that the area to be removed appears to be about 1/3 of the corridor?
No, I don't think so, because this, if we look at map 8, this
Can you just
does
spin the
extend.
map round? Are you looking at the same map? Just to make sure. It's
Yes.
Yes, which map you're referring
you're on that one, yes?
to?
Yeah, yes. So the red area, basically, we're removing about 1/3 of the corridor of trees.
Well, you mean specifically within the application site or the appeal site rather? Because obviously the corridor goes on. as
The
we've
wildlife corridor
discussed, it
which
goes
runs along the
It does,
Midhurst
it
Road,
goes
yes.
all the way to Hazelmere High Street. So in relation to that, this is obviously a much smaller fraction.
Okay, we're talking about within the site rather than right up to Hazelmere. So within the site area, it's about a third that you're going to be removing.
Yeah, from one side of the road.
Okay. Okay, that's it. Thank you. I think that's confirming that. That will do. Thank you. Thank you.
Okay, thanks very much. Is there any re-examination?
Just a couple of points, sir. Thank you. Mr. Jack, just on, you were asked questions by Mr. Brown in relation to other wildlife corridors other than going out from beyond the site. I think he was talking about north-south corridors particularly. What evidence is there before the inquiry to show that any particular wildlife corridor serves function of connecting ecological sites?
Yeah, I don't think that evidence is before the inquiry because these are, as I said, essentially putative corridors based on some people joining the dots essentially between different receptors.
In relation to tree removal on the western boundary, you were shown a tree retention removal plan by Mr. Brown, this one. Have you got Mr. Smith's proof of evidence to hand, which is should be an NID 5.3, I think. It's in 2 parts on the website. I think we should be in part 1, but I'll just check. Yes, part 1. Got that open?
I've got a draft version. I don't know if that would do, or it's not probably not ideal, is it?
Are you on the core documents library?
I've been dropped off it suddenly. That's why I'm just trying to work with what I've got on my hard drive.
We've got a clean hard copy.
Oh, no, I'm back onto Box now. So
You're in there.
I'm going to have to ask you to repeat the reference again.
So it's NID 5.3, part 1. If you've got it, if it is in 2 parts in the version you're looking at. You there?
Yes, I think it's hopefully just downloaded. No, it's only half downloaded. It's
Wonders of technology.
okay.
Thank you. If you could go to page 20, let's start with 26.
Yes.
Yeah. Figure 55, bottom left-hand corner.
Yes.
Yeah. See some buffer planting.
Mhm.
Yeah. In the bottom left-hand corner. And then over the page, and then we've got the tree plants there. And then over the page on 27, see figure 57, arrival appeal landscape plan, which shows canopies as will be delivered once the trees have come to maturity. Mr. Brown asked you about that area to be removed. in the light of the planting plan, what will be the impacts in terms of tree loss and canopy loss down this side of the slide?
It's mostly a short-term impact. Obviously, there'll be a maturation stage for this planting, although that's proposed to be offset by, using very large trees and planting them in advance. So the sort of permanent effect is simply the addition of the access road. And of course, there are already, numerous access junctions along this A286 corridor.
Thank you. I'm not going to ask you any question. You asked some questions about the development plan, thresholds for different kinds of mitigation. We'll come back to that with Mr. Collins, but I won't ask you any further questions at this point. Thank you very much, sir. Thank you, Mr. Jack.
Okay, thanks very much indeed, Mr. Jack.
Thank you.
We will now switch over for, excuse me, for the council's planning evidence. Just whilst Mr. Johnson's setting up, what sort of time do you estimate in chief? I think you originally estimated a couple of hours. How that? Which will take us through, that'll take us through up to towards 5 o'clock, won't it? Probably then move straight on to cross-examination tomorrow, but not today. It makes for a more common sense approach. Okay, over to you, Mr. Cosgrove.
To make me go more quickly, so I've seen that before. So it's an early bar if I'm quick.
Yeah, worth a try.
You've done this before. Thank you very much. So can I introduce Mr. Johnson? Can I introduce you by reference to your proof of evidence, please? In section 1, you tell us that you're Ian Johnson, you're the managing director of Luke and Beck MDP, which is a planning consultancy based in Winchester. You've got a master's in town and country planning and a postgraduate diploma in urban design, and you're a chartered member of the Royal Town Planning Institute. Is that right?
That's correct.
Thank you. Is that, yeah, you're close enough to that.
Yes, how's that?
That's fine. Don't want you to have to lean forward each time, but I think it's fixed. There's no choice. So there we are. Good. You've got some 27 years experience of planning in the UK, advised on large scale applications all over the place, both for all sides, councils, developers. Is that right? And in relation to this case, you were formally instructed in February of this year to provide evidence in relation to planning matters. You say you visited the site. Have you done what I'm alleged to have done and trespassed, or have you been more circumspect about your visit?
No, I've remained within the law on this
Right.
occasion and just walked the public rights of way around the periphery of the site, not on the site.
Thank you very much.
Thank you.
Good. Then you contain the normal declaration at 1.8 of your proof, which applies obviously to both your written and oral evidence. Okay, thank
Yes,
you. Now, as with other witnesses, I think I would like with you to deal with it sort of under topic headings, and we're going to respond to some of the matters in Mr. Collins' proof, and bear in mind the inspector's read your proof and read, in fact, Mr. Collins' proof as well, so he's familiar with the subject matter. Now, can we just start off just to give some structure as well by taking up the planning statement of common ground, which is NID 4.11, 4.11, where there are a number of issues identified under the sort of broad planning topic. Could you just identify what you think the key issues out of those main issues are, please? Section 5 of that document sets out main matters and disputes. What do you think the key ones are in terms of planning?
Yes, of course. Well, the inspector will have seen these already, of course. I mean, really, the council consider the main matter in dispute is that, as was with the previous inspector less than a year ago, that the proposal would fail essentially to preserve and enhance the landscape and scenic beauty of the natural landscape. So the key issue is really it comes down to exceptional circumstances in 5.1 Roman numeral 2. So whether these are exceptional circumstances for the purposes of para 190 to justify the proposed development.
Now, there are obviously a whole range of matters within the 190 umbrella, which we'll come to some of them in your evidence in chief. But the parties agree, I think, further on down in that statement of common ground, that matter, as the parties say, goes to the heart of the appeal. What do you mean that slightly emotive phrase to mean in terms of practicalities of decision making?
Well, I think it's fairly clear through paragraph 190 that there's a framework there set for the decision maker to apply. It's not a rigidly applied framework, because there's a bit of flexibility within that, but it's really hinging around the provisions of that paragraph.
Good, thank you. Now, the other, just a couple of points of context to set the scene. While we've got the statements of common ground out, we've also got an agreed housing supply statement of common ground, which is, I think, at 4.1. So that's the updated 2025, January 2025 housing land supply statement of common ground. And there's an agreed figure of 1.28 years supply set out in the calculations within that document. Can you just look within that document, please? There's a section 4.7 following. There's a bit about buffer, explaining why there's a 5% buffer as opposed to a higher buffer applied. And then there's reference to at 4.10 of that document to the most recent HDT measurement for Waverley. And there's a little table. What does that tell you, just while we're there, in terms of, despite the agreed supply, what's happening in terms of housing delivery in the borough?
Well, I think it's important to recognise that we all acknowledge there's a shortfall in housing, and that was the situation with the previous inquiries, we all know. But of course, what we also need to bear in mind as well is that we have an authority who is actually performing very well with its delivery. It's a continuing trend, as in set out in the table, through the housing delivery test score, that since 2019, 5 years preceding that, 20, 21, 22, 23, year on year, the delivery improved. So it began in 2019 at 85% and then rose to 98, 109, 139 and 154%. So that effectively takes you to under the HDT test, takes you to a 5% buffer, because the authority are performing better than the 85% threshold.
Okay, thank you. Now we'll come back to that housing agreed figure of 1.28 years as we go through your evidence Another point of context from the outset, if I may, the previous inspector's decision, which again, the inspectors looked at already several times, it's NID 3.8. That's the Inspector Bristow decision in relation to this application and site from May of last year. Now, there will be, it appears, a legal debate about whether it's material planning consideration, but from a planning perspective, do you view it as a material consideration?
Yes, absolutely.
Thank you.
I can continue. Just
Yes,
to
please,
give a
Bill.
bit of
Absolutely.
context behind that.
Yep.
Well, you mentioned the legal position, and yes, I'll leave that to the legal experts in the room. Clearly, it was quashed. It was on one narrow legal point, procedural unfairness. Now, from a planning perspective, the approach to the national landscape in the framework remains the same, and as previously, as when the inspector last dealt with this appeal. There was also a 5-year hazard land supply shortfall at the time. That's still the case here. We also had the same development plan as well, the same policy framework at local level and pretty much at national level as well. So I think the planning landscape is very, very similar. In fact, I would go as far to say the planning landscape's now been more weighted against the appeal scheme.
Yeah.
And we'll come on to that in a bit more detail as we go on. But I think certainly there are, outside of the NPPF, there are strengthened duties, and we'll come on to that as well through LIRA and the CRO Act and the PPG. Yes. And so on. But I think the planning landscape has strengthened, I think. And I think there's also a point of the principle of consistency as well. In terms of weight towards that decision, how much weight should be given to it? Well, you have to question, is it really in the public interest to be making a different decision? I think obviously it's up to the decision maker to make that decision, to the inspector, of course. But if that is the case, obviously there needs to be very strong, clear grounds for moving away from that previous decision, because obviously there's a public perception, there's a public confidence here in the planning system. And if we are to move from one appeal decision, which is less than a year old, to a very different one, obviously there has to be very strong reasons for that. So that's just a touch on the principle of consistency, if you like.
Okay. Now, the appellant picks up on some differences, it says, and we'll come to that, but standing back at the outset of your evidence and looking at it in the round as a material planning consideration, what weight do you give it in the balance you apply, or you invite the inspector to apply?
Give significant weight.
Yeah. Thank you. Now, just again, by way of context, it's because it's agreed there's not a 5-year land supply. If you've got your NPPF copy to hand, I don't know whether the latest NPF is a core document. The old one was. Is the up-to-date one a core document?
The up-to-date one is the one that's it's been replaced within CD 8.1, so it is the new one.
So it's just to
So
keep us all on our toes. So it's back in the documents. It's said to be under the last inquiry, but in fact,
it's the new
not.
one. No, it's the new one.
All right, that's where you find. Anyway, I suspect the inspector's got his copies anyway, but just for if members of the public are following it. So wherever you have, Mr. Johnson, if we just turn up para 11 again, just to set the structure. Familiar one for planning inspectors and lawyers, but as it now stands, because there's no 5-year land supply, what happens in terms of policy decision making so far as the NPPF is concerned, by reference to 11D?
Thank you. Well, it's a fairly well trodden path, I'm sure, for a lot of people in this room, but obviously we have presumption in favour. Now, obviously, where there's a shortfall in housing, the relevant policies, the policies which are most important for determining the application, become out of date, and that's under para 11D. Doesn't mean the whole of the NPPF is out of date. It's just those which are most important. Now, if that is the case, then we would apply something called the tilted balance. So the tilted balance applies. However, there is, of course, footnote 7. And footnote 7 is there for a very, very important reason. And the government have reinforced that through various ministerial statements and the PPG and so on. But the footnote 7 essentially identifies that the tilted balance is disengaged, where you would impact on those assets and those sites of particular importance. And as we know, that national landscape is one of those.
Okay. Now, you mentioned, I think, you talk about out of date and looking at 11D. talking about relevant development plan policies or the policies which are most important for determining the applications. There's a list of policies agreed in the statement of common ground. If a development plan policy becomes, quote, out of date in 11D terms, does that mean as night follows day that it has to be given less weight, or what's the position as you understand it in terms of what weight you give a policy?
In those circumstances, I would always go to paragraph 232 of the framework, which is where existing policies should not be considered out of date. Although it's referring to those policies simply because they're adopted prior to the publication of the framework, it's a useful guide because it's also talking about due weight should be given to those policies according to their degree of consistency with the framework.
Yeah. Okay. All right. So it's a judgment, is what you're saying.
Yes.
All right. Okay. Thank you. Thank you. I want to just look again, just in terms of the broader policy. We've looked at the 5-year land supply. Mr. Collins' evidence discusses a lot about the importance of housing need and the very low level and the need for both nationally, but also in this district, a great need, it said, for housing. I just want to invite you just again at the outside to look at some contextual points in the government's policy as amended in the new NPPF, and how we deal with housing and how the government invites decision makers to deal with this housing. So first question, if we just look at paragraph 1 of the NPPF, and it talks about what this document does, providing a framework and so forth. In terms of whether the system is a plan-led system or not a plan-led system under this new policy, what's your position?
Well, I think the government's intention is very clear. Government's very clear in terms of reinforcing the role of the plan-led system. We've always had for a long time, since those long enough in the tooth to remember para, I think it was 54A, wasn't it? But we have a plan-led system, and the government have reinforced that, particularly through the new NPPF.
Okay.
Through paragraph 1.
And when in due course the inspector's looking at some of the matters in particular para 190 of the NPPF, which is, we've agreed, goes to the heart of the appeal and is considering a whole range of issues, but in terms of considering the context and national considerations for housing, how do you see this? The latest version of the NPPF deals with two things really: how and where housing should be delivered, so far as the latest version of the policies. What do you say about that?
Well, I think if I can take you to I think quite a helpful bit of text, if you like, just to help me contextualise some of this, is the ministerial statement, which is NID 7.1.
Yes.
And I think that gives us quite a nice overview of where the government were going with the new NPPF in terms of their direction of travel.
Just let us get there, and if you can give the relevant parts of that you want the inspector to look at. NID 7.1.
7.1.
7.1.
Statement. Yeah.
When was that dated from?
30th of July 2024.
Yeah. Okay.
Last year.
Thank you. Right. So what's the point you've got?
Well, I think the point the government are trying to make here is that yes, we have a plan-led system, but that has to be the driver, if you like, for achieving the government's aims. But what the Secretary of State was also saying in the ministerial statement, if I can take you to, I think it's on PDF page 2, the penultimate paragraph.
Yep.
Scroll down. What the Secretary of State's saying here is that, you know, we can't always wait for land to be released through the local plan, through the local plan system. Now, if an LPA, a council, are looking to develop, to allow, if you like, unallocated sites to come forwards, it's very clearly saying that this must be considered, but only in the context of, and it refers to grey belt, refers to brownfield land, and it refers to green belt only in exceptional circumstances, very, very special circumstances. She then goes on to state that the government are introducing new safeguards to make it clear where the presumption does not apply. And given that this statement came out last summer, we know through legislation for the Lure and so on that those things have started to happen now. So the government are moving forwards very strongly with that, that direction of travel.
Okay, so that's I think of the paragraph, just to check, it's the paragraph beginning, but we cannot wait. Is that the one? Yeah.
Yeah.
And I think you'd be referring to a bit where the 3 lines down where they're so lacking sufficient supply, failing to deliver enough homes. We will therefore also make it clear that applications for sites not allocated a plan must be considered where they relate to brownfield and grey belt land.
Mm-hmm.
Now, in terms of the new strategy in the NPPF then came along in December. When one looks at the NPPF and what it says about brownfield and grey belt, new category of land, how do you see that as being part of the strategy for delivering the 1.5 million homes? What's the government saying about where housing should go?
Well, the government have increased the flexibility, certainly for the green belt through the new concept of the grey belt, and there's a lot of guidance in the PPG on exactly how that's to be rolled out. And they've also obviously strengthened the focus on previous developed land, on brownfield land, and development should only really be refused there. I mean, well, development should be strongly encouraged there. Sorry. On PDL.
Yeah. Okay, and so I don't think it's a matter of dispute that so far as national landscapes are concerned, the test, which is now in 190, similar to the test, just at a different paragraph number before, so so it will be said that there is a route under which one can get planning permission in the national landscape, and that's 190. But what do you say about as it were, the mood music or the context surrounding that exceptional test in terms of how it's changed in relation to where the government and how the government wants housing to be delivered?
Well, the government obviously they haven't introduced any flexibility for national landscape. It remains very firmly as a footnote 7 area or asset. However, other footnote 7 areas and assets such as the green belt have been given greater flexibility. So the government maintained the highest level, I would suggest, of importance on the need to conserve and enhance the national landscape. And obviously we now have a strengthened statutory duty through section 245 of the LURA and section 85 of the Crow Act. And that's something which obviously is now endorsed through the PPG as well.
Yeah, all right, we'll come on to those. Okay, so that's some of the contextual points. Now, in terms of a brownfield and grey belt, and councils up and down the country now have doing some new tests and grey belt, and they're seeking it. What's this council doing in terms of preparation of a new plan? You talk about this in your proof at page 24 in terms of the timings now.
Yes.
So first question, I think it's with Inspector's note, it's your para 9.24 on page 24. You refer
yes.
to a council's executive in 4th of March with the timings there. Are those still as you understand it, the latest, most up-to-date timings for the inspector to have in mind?
Yes, that is correct. Yes.
Yeah. Now, again, in terms of the new policy lands in December, what's your assessment of how this council is getting on in terms of timing, in terms of trying to find and address the issues and policy that it now has from the government?
Well, the government, the council are, along with many other councils, are still having to pivot and adapt to the grey belt scenario now. So they are obviously working towards pulling together evidence in the visioning stage, and they're working towards developing that further through the summer of this year. The current LDS suggests that there'll be an issues and options later in the autumn. So certainly there will be we're certainly in a phase of sites being submitted, sites coming forward from developers, and I represent national house builders across the whole of the South Coast, and that's exactly what they'll be doing. I can assure you right away, they'll be putting their sites in now, trying to get ahead of the bunch and putting those forwards for development to hopefully get them allocated, albeit in draft in an early stage of the plan.
Now, in terms of what this will produce in terms of evidence, or in your assessment, if one gets a plan in about 3 years from now, what's going to emerge sooner that might assist decision makers such as this inspector looking at applications for major development in the national landscape?
So I'm not sure that.
What kind of evidence will emerge underpinning that local plan process?
Sorry. Yes, of course. Well, typically there'll be a call for sites process, which will be typically where the council go out to the general public and developers and ask for any sites that they have immediately available and that are achievable within the next 5 years. That's typically the timeframe.
Well, that's happening now. I think it's not a matter of dispute. That's ongoing at the moment.
That's an ongoing process, yes, and that'll run through this summer and into the autumn.
Yeah, and we don't know the upshot of that process now?
No, we don't know.
What's your assessment about the likelihood of other sites coming forward through that process that for housing?
I'd say very, very likely. We've got a much more pro-development government. We've got a much more flexible framework now, and we have an economy that's certainly has improved over the last few years. So I'd say that the house builders will be quite hungry, obviously, to get sites, particularly in wealthy areas, districts, such as Waverley. So I'd have thought there'd be numerous sites coming forward through that process.
Yes, all right, thank you. Now, in Mr. So if I can give you the reference, in Mr. Collins' proof, can you just turn to his proof, page 47? He's looking in that section about new plan, and he quotes from the leader of the council who wrote in September, I think before the NPPF, saying to Secretary of State at the top of his page 47, the level of growth required to meet the standard method of need is simply unachievable in the borough. And then I'll come back to that point. Then at 445, there's reference to saying WBC admit there's very little scope for grey belt to come forward. And then there's a quote from submissions made to the House of Lords Grey Belt Committee in October. So again, before the NPPF comes out, and there's reference to various figures. And there's a figure that the council at the bottom of that quote, it says the council will review the remaining 7 to 12%. That's land in the green belt that's not in any other designations. So let's take the figure of 7 to 12%. What's your assessment of whether the likelihood of whether sites might come forward from 12% of the district's area?
Well, I think that's not an insignificant number. 12% is potentially of the green belt is potentially quite a large area, and that's the part of the green belt that's not subject to the footnote 7 restrictions.
And grey belt, I mean, obviously since the NPPF, we've had PPG guidance, and anyone who looks at planning every other week, there's a new grey belt decision with a new slant. But what in your view are we learning about how the application of grey belt criteria are actually happening in the planning world? Are they delivering more sites or less sites, or do you not know? What's your experience?
My experience is that in planning consultancy, the world of grey belt is a very healthy area to be in. There's a lot of sites coming forwards, which many of our clients are looking at what they hope to be green belt. And I think what's quite interesting as well from that quote, which Mr. Collins has used in 4.45, is a penultimate line which refers to it's likely that most of this land will make more than a limited contribution to the 5 green belt purposes. Because obviously what grey belt needs to do, grey belt, if you want to justify a site as grey belt, you have to demonstrate that it doesn't strongly contribute to the relevant purposes. Now you have strong, you have moderate, and you have limited. So what this is saying is that there are sites that, there may be more than limited contribution, but there could be quite a few who just have a modest contribution. So effectively would fall within the definition of grey belt.
Yeah. Okay. So there we are. That's process that's ongoing. And I mean, do you take the view that the new government's policy in December, grey belt guidance comes out more recently in March? Do you think this council is going slow in the timetable? I mean, what else could it have done?
No. I think the development industry is often a bit impatient with local authorities, but having worked on both sides of the fence, it's not an easy job, and there's a lot of work to do. But I do think the route ahead is a lot clearer than it has been over previous years. We now have a very clear direction from government, and we have a new framework as well to help with that. So I think that they are moving probably as quickly as they can.
Just take up the last inspector's decision, please, NID 3.8, and just on a related issue, because obviously this is before the new NPPF, before Greenbelt issues, and if you turn to his appeal, paragraph 155 of his decision. And he was assessing the position as at on evidence before him in the early part of 2024. And you'll see he says, I accept plan making Waverley's not previously been quick. However, WC have recently undertaken a call for sites in advance of preparing a LPP1, and then he refers to various dates, which you've explained have now moved forward in terms of the new policy.
Yes.
Context. And he says, well, late 27 may be optimistic. There may nevertheless be scope for other sites to come forward before the end of the plan period as a result of the process and WBC's recent call for sites. And then he refers to a couple of appeal decisions. Now, that judgment he makes, albeit, at that stage, what would your judgment now be in the current context that you would invite the inspector to make, given that this inspector also has a call for sites, but as well as that new policy, grey belt, brownfield policy? What's your judgment in terms of the likelihood of other sites coming forward?
I think it's an improving situation. Certainly, we've got much stronger direction now from government, as I've mentioned, not just through the NPPF, but through ministerial statements. So I think certainly the process will not be slowing down. I'll put it that way.
So, and looking at the last words, the end of that paragraph, the inspector says, in short, I accept limited scope for the housing proposed here to come forward outside the AONB or to be met in some other way. So this is a judgment not dealing with the specifics of alternatives. But what do you say about that judgment now in light of the new policy context and what's going on in this local authority?
In terms of limited scope?
Well, in terms of whether there's scope for housing to come forward generally, in your view on the evidence.
I think there's the scope I'd suggest has improved since the previous decision.
And we're going to come on and look in due course the list of alternatives, the party, but putting all that aside, on the evidence, do you think there's scope or not for sites to come forward?
Certainly there is certainly scope. Yes. Yeah.
Good. Thank you. Now, good. We've done timing and progress. Yes. Next topic. I just want to about context and when we talk about housing need and housing requirements in a local plan, can we now, do you have copies of the NID 13.17, which is the PPG references the appellant kindly produced relating to national landscapes? It's NID 13.17. If you don't, it's also in your proof, so we can go to it in either place. So I take it to your proof for your purposes, but if the inspector wants to look at NID in your proof, page 10, para 6.10. Again, by way of context to how we approach really 190 and housing need in this case, you refer to, again, the inspector in the first appeal, and you refer to part of the PPG, you give the reference at footnote 12, and then you quote it, and it says the National Planning Policy Framework makes clear that the scale and extent of development in these areas, it's talking about national landscapes, should be limited in view of the importance of conserving and enhancing their landscape and scenic beauty. Its policies for protecting these areas may mean that it is not possible to meet objectively assessed needs for development in full through the plan making process. Now I want to put a full stop there. I'm going to come back to the second part of it as it goes on as well. But in that part of guidance that we have for decision makers to look at now, what does that tell you about the context and how this inspector should approach the objectively assessed need, the need we have the calculation at the moment, please?
Yeah, I think that's certainly part of the weighting, the planning balance and the weighting exercise. As you say, it's recognised, the inspector recognised that as a scenario, as a situation. It's also in the natural environment section under paragraph 41, isn't it, of the PPG. So that's when you have an authority that is as constrained as Waverley, large areas of greenbelt, national landscape. There are others, national parks. It's fairly conceivable they're going to struggle to meet their full OAN, and there are provisions within the PPG that allow them some discretion there.
Yeah, I mean, does it follow in light of that guidance for decision makers and indeed plan makers that the level of need we have assessed now, 1.28, when it comes to the local plan process, which is ongoing, and the decision of, in fact, what the requirement should be regard to policy will be anything like the calculation is at the moment. Does it follow or not?
It doesn't follow, no. Obviously, that's a matter for the local planning inspector and the planning and the plan making process, but no, it doesn't follow automatically.
And again,
Right.
again, relevant, all this context when one inspector looks at 190 in the context of the national landscape, but what together with the other changes, what message do you understand the government is giving to decision makers when you read a part of that guidance about objectively assessed needs and it may not possible to meet them in the context of national
Yes.
landscapes? What do you take the
It's-
inspector to take from that when he's considering national considerations in 198, for example?
Well, the government's commitment to delivering housing isn't at any cost, and that we know that through the strength it's put behind the footnote 7 element of Power 11. We know that through the ministerial statement, as I've just mentioned, and we know that through other forms of legislation coming forwards as well, such as the LURA and so on. So it's yes, we do need housing, but there are checks and measures to ensure that when that housing is delivered, it's delivered in the right way and in the right location.
When the inspector, and we'll perhaps come on to a little bit later, whoever's chief of the inspectors, if he's had the time to read Mr. Neam's, the appendix to Mr. Collins, Mr. Neam's evidence and so forth, and there's lots of calculations done, catapulting forward the existing calculated need. Does that take any account of this? And frankly, does it mention this part of the guidance at all in that evidence? Does
No,
it
it
grapple with it?
No,
Does
not at all.
Mr. Collins grapple with this evidence? Or
No.
give it any weight as far as you can see?
No.
And again, Mr. Neame, Mr. Collins talks all about all need in the district, and then Hazelmere particularly, and just have a look at the second part of that guidance as well, PPG. It goes on after that, having talked about the plan process. It says, and they are unlikely to be suitable areas for accommodating unmet needs from adjoining non-designated areas. So, present purposes, is Hazelmere a designated area?
No, it's not, no.
We've heard a lot about the unmet needs of Hazelmere. Any reference in the appellant's evidence to the government guidance that those areas which the site forms part of is unlikely to be suitable for accommodating those unmet needs?
No.
Any Mr. Neame grapple with that when he gave all his evidence, and I can't ask him, but no.
Not that I've seen, no.
No, okay, all right, thank you. Do you think it's relevant?
Yes,
Did the last inspector think it's relevant?
I believe so, yes.
All right, thank you. Now, if we can just move on, please, to some other contextual matters. In terms of 190, we've it's not in dispute that the policy test there in the NPPF is unchanged, save for the paragraph number. In terms of the statutory duty you mentioned, the amended section 85 duty, you cover this in your proof at page 17. So if you could just turn that up, please. Now, again, there's elements of this which go into matters of law, I suppose. But in terms of how you have assessed that duty compared with it in its previous form, what do you say about that in terms of the decision-making process from a planning point of view?
Well, as we know, through section 245 of the LURA, that we now have a revised statutory duty, and that amends section 85 of the Countryside and Rights of Way Act, the CRO Act. So where previously the decision maker, the relevant authority, had to have regard to the purpose of the protected landscapes, there's now a duty to seek to further the purposes of conserving and enhancing the natural beauty of the national landscape. And then with that, there was an associated update to the PPG as well. And as we know, under media realisations and that bit of case law there, that has equal status to the NPPF as well in terms of the weight to be given to the PPG.
And so how would you characterise that duty in terms of a decision maker sitting to your right? How would you characterise that duty compared with what existed before?
Well, it's certainly strengthened. What it also does and makes very clear as well is that it puts the national landscapes on the level playing field in terms of the same status as national park and the Broads, 'cause it deals with all three in this one in the same, essentially.
Now, the last inspector had fairly recently, but he had that duty to consider as well, and he refers to it. What he didn't have in the chronology is what we now have at NID 7.11, which is the statutory guidance issued by the department in December of last year. That's the DEFRA guidance on how, seeking to assist, amongst other things, how decision makers should use and employ that duty. Again, do you consider that to be relevant to this case?
Yes, it is very relevant. Yes.
And as I said, I think in cross-examination to one of the earlier witnesses, and again, in the interest of time, we can go to it if we need to, but there's reference to the importance of management plans and also to dialogue with, for present purposes, the board. Just taking them in turns, as far as the management plan is concerned in this case, it's core document 7.7, and the inspectors looked at it in quite a lot of detail last week. But as a material consideration, what weight do you invite him to give that plan? First point.
Well, I think the management plan has significant weight. It's cross-referenced in policy RE3 of LPP1. So it's embedded into the statutory development plan. It's not part of the development plan, don't get me wrong, but it is certainly given weight within that. And essentially what it does, it sets out, I'd suggest it sets out a strategic context, if you like, for decision makers who are, when applying policy RE3.
Yeah, and and again, if you want to turn it up, please do. You referred it in your brief, but the inspector, I think, will be familiar within that. It has its own suite of policies within the management plan, and we looked last week at a number of them, particularly so far as the council is concerned, policies P1 and P2. And your view in light of the evidence you've heard as to whether those are conflicted with or accorded with, or whatever.
The key policies are P1 and P2. And it's actually, it's worded as quite a balanced document. That's my view. It talks about balancing different considerations associated with planning applications. So it's not an anti-development document. It talks about balance. But then it goes on to say in P1 that great weight should be attached to any adverse impact on the national landscape. And that's a very similar language to that in paragraph 189 of the framework, which is, as we're aware, also refers to great weight in the context of national landscapes. And then moving on to policy P2, refers to development with respect, the special landscape character of the locality, and then continues, gives regard to potential impacts on ridgelines, public views and tranquility.
Yeah, and I mean, obviously, we're not going to repeat the evidence we heard last week about landscape character and visual, and we also have the previous inspector's findings of serious and fundamental adverse effects as he sets them out. Your view in terms of council's case and previous inspector said in terms of those findings of adverse effects and these policies, do you think there's conflict with them or not?
Yes, most certainly, yes.
And again, I'm going to try and take this as quickly as possible because the inspector's already looked at them, but there are a number of representations he's received from the board, I think from the chair of the board and also the planning advisor, Mr. Smith. Again, Mr. Johnson, if you want to go to them, but what weight do you invite him to give those responses, consultation responses in relation to the management plan and indeed the national landscape?
I think it's important to recognise that you have the document, the Surrey Hills Management Plan and the Environmental Design Guide. They're both documents produced by the Surrey Hills Board, and that is the same board who, through Mr. Smith and the chair as well, whose name I forget, apologies, but both have strongly and very robustly objected to this scheme.
Yeah, and what weight do you invite the inspector to give those objections?
Well, I'd certainly give that a very significant weight.
Thank you. We briefly heard about Natural England as well, and again last week the inspector heard about Natural England's role in assessing national landscapes for designation. They've also written in, both in relation to SANG, but also on a number of occasions in relation to landscape issues and natural beauty and qualities. Again,
Yes.
what weight do you invite the inspector to give those views and objections that have been raised before him from that body?
There's a statutory consultee and also the authority for the designation of national landscapes. I would give their comments great weight, substantial weight. That essentially, yes, they've commented on the SANG and in a positive way in terms of how the appellants have been dealing with the SANG, but what they've also done in that correspondence, they've very, very clearly set out their objections to the scheme in terms of the impact on the national landscape. And that's something not to be forgotten about. And you have to read through their comments a little bit further down to really pick up on that. But they're very, very clear on their position.
Now, again, I think you mentioned just almost the final bit of context and the mood music around 190 when the inspector comes to look at it. You mentioned the government choosing just a few weeks ago to update the guidance. And again, this is in the inspector's NID 13.17. It's also referred to in your proof in a footnote. I don't think you set it out, but it's the paragraph 039, revision date 29th of January this year, under the heading, what are the statutory duties of local planning authorities in relation to national parks, broads and national landscapes, refers to the amended statutory provisions and highlights that the duty is particularly important to the delivery of the statutory purposes of protected landscapes. Relevant in considering, it says, development proposals as well. So what do you, again, what does that tell you about, in your view, what importance the government attaches in the context of delivering 1.5 million houses to national landscapes in planning terms?
I think it goes back to the points we were making earlier, that you have a government that are dedicated to delivering housing. You have a government that are dedicated to the national landscape. And yes, there are always compromises with most developments, and those compromises we are beginning to see through Greenbelt, but certainly not through national landscape. And I think that's very telling that the government have gone down the route for Greenbelt, but they certainly haven't touched the national landscape.
So if you're this appellant and inspector looks at their proofs and they make a point of highlighting how the housing need has got worse, it's now 1.28 national crisis for housing, and they make the point that therefore, you know, that feeds into their exceptional circumstances case. Given the context you've explained and what the government has set out, how do you invite the inspector to weigh that shortfall in the context of a major development to the national landscape?
I think the shortfall was there in the previous inquiry. We're not talking about a shortfall that was on the fringes, was 4.8 years, 4.9 years, just below the 5-year threshold. It was a significant shortfall last time, in less than a year ago. Yes, the shortfall has got worse, but it is still there. It's still a long way off the 5 years. But again, going back to my earlier point, that there's a balance here to be struck as well. You have an authority who are actually delivering very, very well and improving on that trend year in, year out. So I think yes, there's no getting away from the fact there's a shortfall, and yes, there's a significant need for additional housing, but it's in terms of the weighting exercise, I would give it no different weight to the previous inspector.
So yes, so shortfall increase in terms of the matters you've been through, you do in your proof in terms of other parts of the NPPF, the other contextual parts, Greybelt, Brownfield, local plan being the way to find sites. Would you characterise the position now in national policy terms compared with that before the last inspector as more favourable to development of the national landscapes, or less favourable, or neutral? How would you characterise it?
It's certainly more favourable to development, but certainly less favourable to development in the national landscape. It's strengthened. It's really strengthened the element of the framework.
And all those matters, we're going to come on to difficulty unless anyone thinks, what on earth am I going on about, or you going on about? In terms of 190 of the NPPF, and its various moving parts, but in the 190A, one's got to consider the need for development, including in terms of any national considerations, and the impact of permitting it or refusing it upon the local economy. So a number of moving bits there. But in terms of the phrase, in terms of national considerations, do you consider the kind of matters you flag up to the inspector to be relevant to that? general
Well,
planning judgment to be
Yeah,
made?
well, certainly, yes, we're talking about housing land supply shortfall. It's a national consideration. We're also talking about national landscape. By its very nature, it's a national consideration.
Good, thank you. Right, next little topic. I want to look, please, with you at some development plan policies. I don't think we've really looked at them in the inquiry yet. And in the context, obviously, for a lot of them of the evidence you heard last week in relation to landscape matters, but also other factors as well. So can we, in no particular order, but let's start with LPP1, which is core document 6.1.
Mhm.
And can we please just look at SP1 and SP2 first of all? I'm going to focus on the policies which you find conflict with. There are a range of them in the statement of common ground. They're agreed, and many of them there aren't conflict with. So I'm going to focus on the conflict ones the council say there's a conflict with. So core document 6.1, SP2, if we look at that, that's at PDF page 20, isn't it?
Yes.
And I just want you to, the inspector will have seen, and might be useful for this exercise to get Mr. Collins' proof out, because within it, in his section 4, which is his policy context section, he's got a helpful table which begins on page 6, policies. He gives a view on whether he thinks the appeal proposal accords with or conflicts with the policy, and then he, in some instances, gives some commentary in the third column. So what I would like to do as efficiently as possible in relation to each of the policies is to, first of all, give your view to the inspector what weight you think that policy has, perhaps drawing on your test of consistency with the NPPF or otherwise, and
Yes.
then give your view on whether there's a conflict or not. And we may just dip in and ask for your views on Mr. Collins's approach as we go along. Okay,
Yes.
so SP1 and SP2, we've got SP2 I think is probably the more substantive one to look at. What weight do you invite the inspector to give that policy, and why?
Well, firstly, as we know, it's referred to in the reason for refusal 1. It's really the first qualifying criteria 1 of SP2, refers to avoiding major development on land of the highest amenity and landscape value, such as the Surrey Hills, AONB, now National Landscape. So in terms of consistency with the NPPF, well, certainly it does through para 190. That's a fairly easy judgment to make. So in terms of weight, it would be given full weight as a policy in terms of the consistency with the framework.
Yeah. Okay, that's SP2 you were talking about, was it?
SP2,
Yeah.
excuse me, yeah.
And do you want to say something quickly about SP1?
SP1 is really it's one of those helpful sort of contextual policies. It's not referred to in the reasons for refusal, but it's certainly helpful, I think, in terms of where it's referring to. There's 3 limbs to it, and the first one being when considering development proposals, the council will take a positive approach, reflects the presumption in favour, etc. That's a fairly straightforward. But it does go down and then refers to, it's very much in line with para 11D of the NPPF, and it starts to draw out right at the bottom of that policy that where adverse impacts are at play, or there's a conflict with the framework, then obviously it's talking about, it's essentially a tilted balancing exercise applied at the local level.
All right. Now, don't speak too fast, because the inspector will, and I can't take a note. I suspect the inspector can't either. On SP2, which you talked about there, you gave your view as to why it's consistent. Now, Mr. Collins will see in his proof of page 26 considers it to be out of date, and he's right in the trigger sense of the no fibre supply, but he goes on and gives some more commentary on it, and he says the appeal scheme accords with it. So there's an issue between you there, is there, as to whether the appeal scheme accords with that policy or not. What do you say about his view, as you understand it?
Are you seeking my view on whether the policy is out of date?
No. What weight do you give him? Whether what your view on Mr. Collins' assertion that there's no conflict?
There's a very strong conflict, a clear and strong conflict with that policy.
All right. So far as let's go on to the RE1 and RE3, which are also in this part of the development plan. A similar exercise in relation to RE1, please. What do you say about that policy?
Well, RE1, as we know, is dealing with the countryside beyond the green belt, and it's what it's seeking to do. It's protecting. It's a protectionist type policy, isn't it? The intrinsic character and beauty of the countryside will be recognised and safeguarded in accordance with the NPPF. The supporting text also refers to 13.6. It refers to in accordance with the NPPF. So it's certainly something which you would give full weight to because of beauty of consistency with the framework.
Mr. Collins disagrees and gives it reduced weight owing, he says, to a lack of 5-year land supply, which is let's deal with that's a common perhaps difference between you. He says, well, there's no project. Given the context you talked about and the importance you talked about, where do you see the difference lying in those judgments between you and
the difference here, and also this is my view shared with the inspector as well from the last appeal, but this is my view, not the previous inspector's view I'm presenting here. This policy is very clearly sits within the world of footnote 7, and it's a very dangerous path to go down if you start looking at all these policies, whether it's another footnote 7 areas such as floodplain. If you start putting those to one side and saying they're out of date because of the housing land supply shortfall, that's a very dangerous path to go down, and say that's wholly inconsistent with the framework.
RE3, this policy, it's on PDF 64 of CD 6.1, in particular, focusing in on the part which says new development must respect and where appropriate enhance the distinctive character of the landscape in which it is located. Now, again, in light of the evidence we've heard, landscape character, what's your view in terms of that policy's weight and conflict, please?
Thank you. Well, and again, another policy referred to in the reason for refusal 1, so it's referred in the decision. It is consistent with the framework, and more specifically with paragraph 189 of the framework. It talks about protection enhancement of character and qualities of the OMB, and goes on to, this is where the hook into the Surrey Hills AONB management plan appears in criteria 1.
Yeah.
1 of that policy. So I'd certainly give that policy, in my judgment, gets full weight on the basis of its consistency with the framework.
Now, Mr. Collins' approach, again, he reduces the weight because of lack of 5-year land supply. And then he says at page 29, overall, the policy is not breached. And I think he takes that as a view he takes with other policies as well, that because in his view, there's an overall compliance with 190, when you look at all the evidence he puts forward, he says, therefore, when you look at that policy and the wording in it, there's no conflict. But what's your view on that approach as a planning approach of an application of policy like this?
I would wholly disagree with that, and specifically in relation to if we're going to paragraph 190, it'd be C, 190C, where it refers to a detrimental effect on the environment and the landscape.
Yeah. Okay. Now can we, for present purposes, move on to part 2, which is core document 6.2. So the more recent part of the development plan, and there are a number of policies here. DM11 is one of them, and then we have DM15 as well. So let's look at those policies, please. See where the difference lies. Let's start with DM11. What do you say about that? That's dealing with retention of woodland as it sets out.
Yes, well, correct. Yes, it's all really about retention of woodland. DM11, retained woodland and important trees, grouped trees and hedgerows. And then as you read down the policy, the penultimate sentence, I think it is at the bottom there, proposals which would result in the loss or deterioration of irreplaceable habitats or detrimental impact on the landscape character of the area will not be permitted unless there are wholly exceptional reasons and a suitable compensation strategy. So my firm view is that the appeal scheme is in conflict with that policy, and that policy should be given full weight.
Okay, DM15, please. It's a criteria-based policy.
Yes. So the policy, where I'll go to with this policy would be criteria B. So in rural areas, development should, criteria B, recognise the natural beauty and undeveloped character which is intrinsic to the open countryside, together with the distinctive character and pattern of development in areas of urban rural transition and rural settlements while making efficient use of land. So yes, there is a conflict here.
Yes. And I think that's one of the ones
Also-
Mr. the Inspector's note, Mr. Collins agrees there's a conflict, page 38. He says conflict, although reduced wage should be applied owing to the absence of 5-year land supply. So that's that similar argument again, which you've traversed already.
Yes. Yeah, and just to add a little bit to that, I think to read it into the supporting text just gives a little bit more weight to that policy. In paragraph 3.35, which refers to the introduction of substantial built form into the countryside, has the potential to have a harmful urbanising impact on the countryside, including in areas adjacent to existing settlements.
Yeah. Good, thank you. Right, moving along, we've got the neighbourhood plan, and there's a policies H9 is referred to in the reasons for refusals, I recall. So in the evidence, there's quite a lot of reference to H1,
Yes.
and the last inspector referred to it, and Mr. Collins accepts conflict with H1. But for present purposes, I'm just going to ask you to comment on H9, and again the differences between it. It's another tree and woodland and hedgerow policy. What do you say about that in the context of the scheme and the evidence you've heard?
Yes, well, it's obviously it's a policy that's referred to in the reason for refusal. It's a policy that's part of a made neighbourhood plan, so forms part of the development plan, and it is wholly consistent with policy DM11 in terms of its really what's driving behind it is avoid, well, to quote the policy, development proposal should avoid damage to or loss of mature or semi-mature trees of value other than in exceptional circumstances.
Yeah.
And I would give that policy full weight.
Thank you. Now, just thank you for that on policy. I want to move on to another topic now. Just in passing, one Inspector may be wondering, who may know the answer already, when LPP2 was being made and being considered in terms of the evidence, was the appeal site one of the sites that was put forward for consideration in the part of that process?
Yes, it was. It was considered, and it's in the court document 7.24, and that was a topic paper.
Right.
That informed it.
Do you need, I mean, perhaps give the inspector a note and he can, was it site 987?
It's site 987, that's correct. Yes, and it is identified, and it is referred to as the site at Red Court, Scotland Lane, with capacity for, it was assessed on the basis of capacity for 250 dwellings. Whether that's exactly the same site as what we're dealing with here, I'm not so sure, because there's not a plan that sits with that document. But if it's not the exact site, it's in the approximate area. But the important point really is to make is that site, yes, it was assessed, but it was not taken forward as an allocation.
All right. Now, Mr. Collins' evidence.
Mr. Cosgrove, just wondering, short
Absolutely
mid-afternoon break?
perfect timing. Yes,
Is that
thank you. Yep.
yeah.
Good. Thank you, sir.
Okay, let's just take a short pause then. Quarter to now, 5-2. Thanks. Okay, let's resume then, please, Mr. Cosgrove.
Just 1 point, just picking up on the previous inspector's decision at NID 3.8. 179 of his, the penultimate paragraph of Inspector Bristow's decision, he formally finds conflict with a range of policies which are broadly the same as the ones you've just been through. And then he concludes there would be a conflict with the development plan as a whole. Do you agree or disagree with that conclusion?
Yes, I do. Yes.
You agree or disagree?
Sorry.
It's a very lawyerly answer you gave there. Agree or disagree?
No, I'm not trying to argue it both ways. There is a conflict with the development plan as a whole.
Fine. Now, in Mr. Collins' proof on page 19 at the bottom of his page, he has a innocuous looking heading, other relevant appeals, applications and allocations, and then there follows, he says, I cite some relevant appeals which he considers, quotes, address a number of pertinent matters of relevance to this proposal. And then he sets out a number. Now, trying to deal with this efficiently as possible, do you have any, first of all, standing back, do you consider the various appeal decisions he refers to are going to particularly assist the inspector in terms of relevant issues in relation to this particular case or not?
I have to say I don't.
Yeah.
Obviously, there's the well-trodden phrase in planning is every site on its merit.
Yes, okay. He's raised them. Some of them actually the previous inspector looked at and grappled with in his decision.
Yep.
What do you want to say about some of those points, about some of the decisions? If we start with Sturt Farm, which he refers to on page 20.
I mean, this is a good case in point. It was a scheme roughly similar size, 135 dwellings, but it was in many other ways very different to the appeal scheme. It was a residential properties along the majority of its northern boundary, had a moderate to minor adverse landscape impact, as referred to in the environmental statement. And there was already an existing vehicular access off Sturt Lane.
Okay, so again, you're saying that generally that's not going to assist the inspector much in your view, or
No, I don't think it does.
okay. Thank you. Was that, and with that? Yes, as with all of them, that predated. I think that was from some time ago. Did it predate the latest statutory duties? You understand it?
Yes, it certainly did. It's got a reference of 2014 on the application reference.
Okay. Now, trying to be as efficient as possible. The next one he refers to, I think, well, he refers to actually at 317. It doesn't have its own heading, but there's a reference to a scheme on Hedgehog Lane, validated in January of this year. 16 dwellings. Talks about the history.
Yes.
What do you say about that? I mean, how there's a bit of evidence. Is that?
I think there's a little bit of overlap here because I think that's one of the sites in our agreed list, site 14. But that is a site that had an application submitted, and I think it was submitted not so long ago in December 2024. I believe this is the same site, and that application has been withdrawn last month. The reason for that was that the applicant hadn't undertaken the correct dormouse survey work.
Right.
There are no other objections, but I would assume that site will come back in as an application, probably once next survey season has been completed.
Okay, thank you. Now then on the top of page 21, there's reference to the Royal School site, which is an allocation which comes up in various parts of the evidence. We've heard a little bit about it in the SANG context. And again, are you familiar with that site?
Yes, I'm very familiar with that site.
Yes.
It's an allocation obviously as well.
Why are you, it sounded a bit, why are you very familiar? Do you know? The,
Yes, the applicant is Carla Holmes.
yeah.
Who had been a client of mine. That regional office has been a client of mine for some time. So I'm aware of the situation with that application. I can give you a bit of context if that'd be helpful.
Well, first of all, yeah, I mean, help us with the SANG issue. I was asking Mr. Jack about that, and I was putting to him the proposition that it was proposing a SANG solution on site, but wasn't relying on the appeal side. What can you tell us about SANG and what the state of play is in relation to that site, please?
Well, with the Royal School, there's a SANG solution both on and off site. There was a Natural England objection going back some time now, I think to 2023, I think.
Yeah.
The application has been progressing since that time. It's stalled, not because of that as an issue, but primarily because of a spot listing of the school building, and that has essentially required a lot of reworking of layout plans and so on. So what Kyla Homes have had to do is go back to the drawing board a little bit and respect the setting of that now new listed, grade 2 listed property. So it's not stalled or failed because of a SANG solution. It's for a different reason. Now that application is being amended currently, and I've had conversations with the case officer. That amended plan is expected fairly imminently.
And obviously that's an allocated site, unlike the appeal site.
That's correct. Yes, in LPP2.
Yeah. Okay. Anything more you want to say about that? This I will touch back on it, I think, when we come to alternatives. But do you think it's going to particularly assist the inspector in terms of considering the site before him?
In terms of comparables, it's a very, very different site.
Yeah.
But it's a site that is progressing, and obviously being an allocation, that puts in a whole different ballpark when it comes to land release. Yeah.
And then there's reference, he refers as another relevant appeal, he says, is the phase, what's known as phase 1. Was it actually called phase 1 in the application document?
I don't think it was, no.
Become phase 1, but there we are.
Yeah.
How relevant is that going to assist the inspector in relation to this 190 National Landscape Test, which everyone agrees is at the heart of this appeal?
I assume the inspector may have picked up on this already, that it's an area of great landscape value, so it's not within the national landscape. So it has a completely different policy context, the appeal site.
All right, thank you. Then the next one you mentioned is land north of Queensmead, Chiddingfold. I think that's an approval, he says, for 78 dwellings approved, I think, a couple of years ago. Comparable to this scheme where?
No, no. It's like chalk and cheese, really. This is a site that's it's within the settlement boundary. It's allocated in a made neighboured plan, and so it's been through the scrutiny of a neighbourhood plan examination, and the examiner was clearly satisfied that the site was appropriate for development.
Okay. Then we have reference to on page 22, the Turndon decision, which has went back and was determined, given approval in November 2024 by the Secretary of State, and inspectors references NID 7.19. And there was a finding of exceptional circumstances made there by the inspector and adopted by the Secretary of State with the reasoning given. What do you say about that in terms of its assistance for this scheme before the inspector?
The similarity is around about the similar scale. So that was 165 dwellings. That's probably where it starts and ends in terms of similarities. It was a proposed allocated site. It was, as when I say proposed, it was allocated in an emerging local plan. So clearly at the time of the decision maker was well aware of other sites that were coming forwards through that plan making process when applying paragraph 190 of the framework. As part of the assessment of 190C, the overall effects on the OMB, then OMB, now National Landscape, was moderate adverse, and that was at completion. So really quite different to this site, and this was picked up in the last inspector's decision in paragraph 171, where the inspector referred to, he drew on the fact that this is a very different weighting exercise to the appeal scheme.
Yes, I think in fairness that was an earlier version of Turndon, because this Turndon decision postdates the last inspector's decision. It's November 24th. So it's gone back.
It's gone.
Looked at. So I think, in fairness to you, there was reference to Turndon, but that was an earlier stage in its life. If we just turn up NID 7.19, which is the Secretary of State's decision in the inspector's report, which is quite a long read. And so I'm sure the inspectors will have a chance to look at it in full. But just on the one point you picked up, we go to in the Secretary of State's decision, PDF 20, electronic page 20. I think that's right. No, it's PDF 7, forgive me, Para 20. Got my notes wrong. Yeah, there's just picking up, so the inspector can just see the point you are speaking to, I think. Para 20, yeah. Applicants, just various things. I think I've got the wrong reference. Hang on. Para 23, excuse me. Para 23, forgive me. Yeah. So she's
Yes.
talking about representations and refers there to the draft allocation, the bottom sort of third of that paragraph. Furthermore, it says she considers the policy STR, CS1, and draft allocation are consistent with the relevant policy of the framework. In the particular circumstances of this case, she therefore considers that that policy and draft allocations in the emerging local plan are most relevant given they propose to allocate housing in the application site and carry significant weight. And then she later on puts that into her findings on exceptional circumstances. So again, there's lots to talk about in this case. I'm sure you're going to be asked a lot about it. You can deal with it with Mr. Ricci. But what do you say in terms of, from your point of view, whether it's a comparable in terms of similarities that would assist the inspector in determining the case before him?
No, it's very different. And it's not just because it had a draft allocation, it's really the stage that draft allocation had reached in the plan making process. And I think there's reference in there to the fact there's no modifications as well. So effectively, that draft, at the time of that decision, that draft allocation had been through the scrutiny of a local plan review process and was not subject to modifications. So I would suggest it's very, very close to being adopted, having that level of weight you'd apply to an adopted allocation.
Yeah.
So very different to the
And I think, again, perhaps come to it in a while, but in terms of the way the inspector, I'll emphasise the inspector in the long report, dealt with alternatives and the facts of that case, and the point about allocations were not alternatives, and you needed to look at the extent to which alternatives could fulfil the entirety of the objectively assessed need. So that's an approach which I think the appellant relies on, and Rich and Mr. Collins rely on. So the inspector to some extent did that there. What do you say about that? Assuming that to be the position, does that mean this inspector has to do that in this case? And is the context the same?
No, well, I'm assuming that I think I get the point. I think I'm assuming that the inspector was aware that there were many sites coming forward, so there were alternatives, certainly alternatives outside of the national landscape in terms of the application of Para 190.
We'll return to that in terms of it's really about an approach to the way alternatives are looked at and what are alternatives and what you need to find. But we'll come back to that.
Yeah, I get the point. Yeah.
Now, other cases just in this section that Mr. Collins treats us to, he also mentions a case called Little Sparrows, Sonning Common in Oxfordshire. Again, that was looked at the last inquiry, as I understand it. I wasn't here. Inspector mentions it. What do you think that's going to assist this inspector?
In terms of the Sonning Common, the Little Sparrow site.
Yes.
Yes, thank you. So I think the point, the key issue with Little Sparrows was that the inspector took the view that that site didn't particularly form a representative site in terms of the special qualities of I think it was a Chilterns AONOB, but it was really a point I think he was drawing on the quality of that site in landscape terms.
Yeah.
He was weighting it that way.
Okay, Great Missenden, it's the next case. It's a Chiltern District Council as it used to be. Case 34 dwellings, Park Brownfield site, as I recall.
Yes.
Again, your view on whether that's going to provide as a material consideration any assistance to this inspector?
I don't think so. Unlike the appeal site, I mean, it was the inspector considered the site had I think you referred to a neutral contribution to the AONB in longer views. So, and I think that site had also been promoted through a SHLA, like a housing and economic land availability assessment, and identified as appropriate to accommodate housing.
Yeah, thank you. Cheltenham case, he refers to 329 Oakley Farm, Cheltenham.
Yeah, but in some ways a little bit similar in terms of the housing land supply. There was a shortfall there, but really that was very, very different in terms of its physical characteristics, bounded by residential development on 3 sides and what's described as an engineered landscape on the 4th side. So
Okay, so I think that's, so the upshot of those are, again, materially assistance to the inspector or not, having reviewed them all.
no, this goes back to the first point about
Yeah.
sites and
Okay.
on their merits. Yeah.
Good. Now, the next topic, I'd like to turn and look at the provisions in para 190 of the MPPF with you, please, in light of some of the context we've been through. So if we turn up 190 wherever you want to find it in the MPPF. I'm going to just annoy everyone by going slightly out of order and go to 190B first of all. Now, just, I suppose, even before one looks at that, some just general points about how you as a planner approach the various matters in 190 in terms of, are they tests, are they criteria, are they matters of judgment? How do you approach them, and how do you invite the inspector to approach them?
They're certainly not tests, and it's not a tick box exercise. The area which I think we're both clear, ourselves and the appellants are clear on, in terms of this is a major development. So in the opening sentence, 190 refers to major development, and we're agreed on that through the statement of common ground. But after that, I think this is where we are really quite adrift in terms of approach, because what 190 is trying to achieve here is a broad judgment to assessing proposals within the national landscapes. It's not a narrow assessment that hangs off ticking A, tick B, tick C. That's not what the government intended. And the key is the consideration of such applications should include an assessment of. So it's a very broad and open-ended process.
Yeah, and the ultimate test in the STEM is exceptional circumstances and where it can be demonstrated developments in the public interest.
Yes.
Twofold. Yeah. Okay. All right. Thank you. Now going to look at B and the various moving parts to 190B, which reads requires an assessment of the cost of and scope for developing outside the designated area or meeting the needs for it in some other way. Now, I asked you at the outset of your cross-examination about the general scope and possibility of meeting for it through call for sites and so forth. And so again, before we even look at alternatives and the list of agreed alternatives, is there evidence anyway to address this criteria, or this part B of 190?
There's no strict approach. It's perfectly reasonable to consider a wider assessment, even than looking at just alternative sites. As we mentioned, the call sites process, the emerging local plan, and so on.
Yeah. Okay. Thank you. Now, in terms of other matters, in terms of the cost of development, do you understand there being any point advanced by the appellant saying it would be cheaper to build this in the national landscape than it would to build it outside of the national? Any of those kind of arguments in terms of cost?
No, I don't think there's any
Right.
disagreement there.
Okay.
It's a fairly neutral point, I think.
All right, thank you. In terms of that phrase at the end, the inspector sees meeting the need for it in some other way, would the emerging local plan process be a mechanism that could do that in your view?
Yes, absolutely. Yes.
Yeah, okay. Now, so far as in this case, the inspector's been invited to look at alternatives, let's just look at some of the evidence relating to that, please. Now, for this exercise, again, I want to try and deal with it as efficiently as possible. We've got your table in your proof, which is in your Appendix 7,
Yes.
erroneously called Appendix 5. It should be, but it is in Appendix 7. It should
Yes.
be Appendix 7.
Apologies.
It's your table of sites with your assessments of the list of 18 alternatives.
Yes.
And then could we just, as a comparison of various places we could go in the appellant's evidence, but in Mr. Collins' proof, he has a table from memory 6, I think, which is on page 6.1 on page 68 of his proof. table 6.1, which he calls his summary of alternative sites. Now, just before we look at some of the, I just want to work out, there's quite a lot of arguments here about what is an alternative or what can be an alternative. The appeal scheme is proposing to deliver 111, up to 111 houses. When one looks at 190B, what in your view should be the focus on? In other words, should it be on the particular scheme of houses or some general provision of housing? How should one approach it?
It's not a closed exercise. It's a very broad assessment. So if you are going to take a fairly narrow approach and just look at alternative sites, it could be a range of alternative sites. It could be in terms of meeting the 111 dwellings. It could be a number that cumulatively contribute to that equally.
Yeah.
The way it's worded is broad enough to look at. Could even go as far as say sites in the national landscape.
Yeah. But what, in terms of the exercise, there may be a difference between you and the appellant, we'll see, but your evidence, you explained that you're comparing, you've got 111 schemes proposed, you're looking for places where 111s could be developed outside the national landscape, to some extent inside in your evidence. That
Yes, that's
exercise, comparing like with like, is that what you say is the appropriate way to do this?
Very much so, yes.
Right. Now, there have been other appeal decisions, and Turndon might be one, where some inspectors have taken the view that unless there are sufficient alternative sites to meet the whole of the objectively assessed need in a district, unless there's that, then there is no alternative. Now, this was a debate I think had at the last inquiry. What do you say about
Sorry,
that?
can I just interrupt?
Yes.
Could you just run that one past me again?
Well, yes, so the propositions, I think, so this is from the Turndon and other cases in Wealden, that it said if you've got to ask yourself, is there sufficient alternative sites available to meet whatever the need is in a given area? And unless you've got all those pinned down, then there is really no alternative but developing. So that's one approach. And is that an approach you think is appropriate in this case?
No, I don't. And I think paragraph 190 certainly doesn't push you down that route. It talks about, in terms of 190B, just refers to meeting the need in some other way.
I mean, is there, put it simply as this, as you understand the policy context and guidance, does the government say there's only one way you should assess alternatives, or is it a matter of judgment for each decision maker?
It's absolutely a matter of judgment, and obviously the last inspector applied that judgment.
Right. Okay. Well, okay, we'll see about that. One of the other points that's just taken, we just deal with it, cuts across all the alternatives. There's also a point taken that if a site is allocated, that's not really an alternative that decision makers should be looking at in the context of 190B. And some of the sites you rely on and speak to are actually allocated sites. So what do you say about that contention?
190 doesn't restrict you from looking at allocated sites, and I think there's a bit of a danger here as well, that it's quite easy sometimes perhaps to fall into the trap of, when you're looking at alternative sites, if you're going through a 5-year housing land supply assessment, looking at sites, you wouldn't look at allocations because they form part of the supply. This is a very different exercise here. We're not looking at 5-year housing land supply. We're just looking at a like-for-like comparison of alternative sites that could accommodate a similar level of development, 111 dwellings.
Another point of approach, which may be an issue between us, there's some suggestion, I think, that one should only really be looking at alternatives in or around Hazelmere rather than looking further in the district or indeed elsewhere. That's not an approach you take, but what do you say again? Is that something you think the inspector has to do, or is it again a matter of judgment?
No, that's certainly a matter of judgment, and the local plan recognises, as we're aware, that there are other settlements such as Farnham and Cranley, which are far less constrained in landscape terms, that can accommodate growth. So certainly we are certainly not restricted to looking at Hazelmere.
Yeah. And then final contextual point, a number of decisions have made this point, and that, when you're at a Section 78 inquiry and you're looking at alternatives, it's not ideal And it's often to be said, well, this would be much better done through a local plan process, but there we are. What's your view on that? How artificial an exercise is this at the end of the day? Or how comprehensive an exercise actually is it for the inspector?
I think it's a comprehensive exercise, but it's a fairly narrow exercise because, as we've spoken about, there are many other ways that you can look at alternative locations for development.
Yeah.
It's not just through alternative sites; it can be through core sites, through local plan review.
All right, now, we've got with all that said, we've got it's got an officer lurking with documents. I don't know whether this can wait or whether you look as though it's urgent. Right, leave them and we'll deal with them later. Thank you very much.
Thank you.
Well, thank you. Right, thank you. So let's do them in numerical order. And there's clearly some of them the appellant says shouldn't even be looked at. So let's go site one. The exercise I want you to do really is in relation to each site quickly and efficiently, in light of the appellant's evidence, particularly now you've looked at it. Is it something you say is preferable and could be an alternative in your analysis to this proposal? Okay.
Yes.
So site one, Hazelmere Quayside, West Street. What do we say about that?
Certainly a preferable site. It's adopted local plan allocation. It's within a settlement boundary, within the town centre, not subject to any statutory landscape designations.
And the issue that I think Mr. Collins, the inspector, says, well, that's because that's allocated. That's not really an alternative. Okay, so that's the point you talked about.
Yes.
It's a little different. Site two, we've touched on this. This is our old friend, the Royal Junior School. Again, allocated site, number of dwellings potentials down as 90. Again, Mr. Collins says, well, it's allocated, therefore it's not an alternative. What do you say about the site generally?
Generally, it's a good location to accommodate a similar level of development. I think it's 110, 90 dwellings, isn't it? It's 90 dwellings proposed on that site. But it's, as I say, it's an allocated. It's PDL as well. It's a brownfield site. It's allocated, but I've included that within my assessment.
Three, Fairground Car Park, Weyhill and Hazelmere, an allocated site.
Yeah, adopted allocation, council-owned site within the settlement boundary, very close to town centre, railway station. And I understand I'm informed by Property Services that an application is to be submitted end of 2026. So, yeah.
Old Grove, High Pitford, Hindhead. Is there any update on that one actually? Is that an allocated site?
There is, yes. It's an allocation and previously developed. But this site did have an application at the time I was preparing my proof, since been granted permission on the 27th of March.
Okay, so that in fairness should be crossed off as an alternative.
Should be
because
struck off.
it's got some housing. Okay.
Yes, and that was for 40 dwellings, I think.
Thank you. 5, site in Cranley. And I think this is one of the ones that appears Mr. Collins accepts is a sequentially preferable site, though he says capacity is limited and it can't provide SANG. So what's your assessment of that as an alternative, please?
So just to go back one very quick step, quick correction in terms of the approval.
Right,
Sorry,
Yeah.
very quickly.
Yeah.
It actually approved for 18 dwellings.
All right, thank
So it
you.
was assessed at 40, but approved for 18.
Right.
Sorry. So site 5.
Yes.
Yeah, well, within a settlement boundary, previously developed. Yeah, it's certainly a good location.
Well, in your table, there's various, when the inspector sees under each entry, landscape value, susceptibility and sensitivity. Is that the exercise that Mr. Petru explained how he'd done last week?
That is correct, yes.
I should ask, have you been to all these sites?
I've visited all of these sites, yes.
Thank you. Okay, 5. So 5, that may be some common ground between you, or may not. We'll see. Site 6, please.
Yes, a relatively small amount of development on a site. Reason being is it's confined to the southern part of that site, which is closer proximity to services facilities and landscape reasons. But it's a good alternative, albeit only 5 dwellings.
7.
7 is St Nicholas Junior School.
So I think this is one where Mr. Collins indicates he agrees it's sequentially preferable, though capacity is limited and cannot provide SANG, he says. What do you say about that site?
Sites for 75 dwellings. It's an allocation, again, previously developed sites within the settlement boundary. So the principle is fairly well established.
8, Old Park Lane, Farnham. So 83.
Yes.
What's the issue here as you
Well,
understand it?
this site's currently subject to, I believe, subject to an appeal. I think it's an inquiry in February of this year. And I think the issue there was really the fact that it was located outside the settlement boundary. But in terms of other planning issues, in terms of statutory consultee objections, no flood risk, no heritage, no ecology objections. So it's well located to the settlement, accessible, I'd suggest, in terms of sustainability considerations. But it is, nevertheless, it has been refused, and we await a decision of the inquiry.
All right, thank you. Site 9, Lower Weybourne. I think this is one Mr. Collins accepts is marginally sequentially preferable in his table. 140. What do you say about that one?
This has got a bit of a negative planning history as well behind this site. However, it's not subject to the same level of landscape constraint as the appeal sites. I believe it's in a local gap, but it's certainly not in a national landscape. I think there were issues previously with highways, and I believe they were resolved through a statement of common ground at last inquiry. So it's a better alternative in the context of it's not in a protected landscape, and it actually relates very well to the urban edge.
Yeah. So next slide, please.
Next slide.
Hedgehog Lane.
It's 10.
I think there's an issue raised by Mr. Collins in his rebuttal as to whether, or to what extent this site's in the national landscape, or seem to be conflicting plans. One says a lot of it is. Can you inspect on that?
Yes, it's actually quite a sustainably located site. It's adjacent to the settlement boundary, and I think that there's reference as well in terms of policy H11 of the neighbourhood plan. But the important thing to recognise in policy H11 is it doesn't actually rule out development within they call it the green finger. It doesn't rule out development. It accepts the principle of development. It just requires it to have a heightened awareness, if you like, of landscape impact.
11, please. That's the land southeast of Hazelmere, Sturt Road.
Yes, the site lies outside the national landscape. National landscape's actually just close to the east of the site, so it abuts the settlement boundary, and it's pretty well, having visited it along with all the others, it's pretty well screened by boundary vegetation. So in terms of is it an alternative site, yes, it is.
Thank you. 12.
12 is 12 abuts 11, so they're almost the same site in some ways, but very similar situation.
Thank you.
Yeah.
13.
13's yes, quite a small site within the settlement boundary, previously developed. I think there's 2 dwellings on the site at the moment, so certainly the principle is fairly solid, fairly sound for residential development.
Thank you. Next one, please.
13. This is the
Petworth Road.
Hedgehog. Yes, I think this is the site which had the application and had been withdrawn fairly recently, and the reason for that was failure to have the adequate dormouse surveys. But I would assume that will be resubmitted fairly shortly. I'd assume probably after next survey season.
Thank you. And then number 14 is Longdean Fields. Previous draft site allocation, I think. 25 dwellings.
That was I think that was the one I was just talking. That's the same one as we're just talking about. I think Hedgehog.
Was it?
Yes, I think we're on to 15 next.
Give me, that's me. That's
where I am.
Yeah, there we are.
Just about the one.
Just keep testing your foot. Now, to take it quickly, the remaining 4, what do you say about them as whether they're sequentially preferable or not, or better alternatives?
I don't think these are I think, yes, okay, they're adjacent to the settlement boundary. They're within the green belt. They're within a national landscape, but they are certainly not preferable to the appeal site. The landscape value susceptibility sensitivity is high on advice from Mr. Petro on each of these 4 sites. So I think these and they're roughly 30 dwellings, 30,
Yeah.
50, yeah. So
Okay.
not preferable.
Now, just look at your 927. I think we need to do some recalculation in light of some of the missions and so forth. What I would really, and you set up some figures, what I want you in terms of your numbers to tell the inspector from your exercise, how many out of the 18 sites do you think could be considered alternatives, either on their own or in combination? And then roughly what number of dwellings are we talking about in terms of capacity?
I think where we end up is 14 out of the 18 are preferable.
Yeah.
And I can give some numbers to that if that would be of help.
What's just to give a feel of how many dwellings do you say that could?
Well, if you were to remove the
Yeah.
last 4 sites, they cumulatively they're under the assessment we've agreed have a capacity for 170 dwellings. So if you take off that 170 dwellings from my total in my table 2, which I got to 844. So if you take off the 170 plus the Hedgehog Lane site 40,
Yeah.
I think you get to 634 with my maths.
Right. But so it's over 600, you say,
Over
under this
600.
exercise.
And so over 6 times the.
Okay. Now, we'll ask Mr. Collins, but from reading his evidence, what's your assessment? I mean, clearly there's some sites he's indicated in that table we've looked through he thinks preferable. He doesn't agree with you a lot of them, but do you understand him to be identifying some alternatives or not?
No, I think Mr. Collins' table is a very narrow approach to applying paragraph 190.
Yes, I accept that, and there are differences, but at the end of the day, even on his evidence, do you understand him to have identified some alternatives at least?
Oh, yes, sorry, excuse me, yes.
Yeah, all right. And
Yeah.
now and the position and there were differences as to approach to what could be an alternative. Is that, as you understand it, a similar position that the appellant puts different numbers, slightly different sites at the last inquiry?
Yes.
We look at the previous inspector's decision, please. Again, NID 3.8. When he addresses the issues of alternatives. And if you look, please, within his decision at paragraph 152, the inspector says, turning to the NPPF 183B, and then he refers to Mr. McDermott's evidence, sets out an analysis of possible alternative sites in the borough. It rationally concludes there are few sites that would be preferable in landscape and visual terms, none at the urban edge of Hazelmere. Nevertheless, the corollary is that there are such sites with potentially lesser effects in landscape terms alone, now the sole matter of dispute. The appellant explains how on the face of it, Farnham and Cranley are less constrained. There is, moreover, nothing respective sites capable of delivering fewer than 50 units that might collectively amount to similar housing delivery as the appeal scheme. And he goes on and makes some other points later on. Now, just in terms of the evidence is slightly different, but the thrust of it, as you understand it, is it broadly the same position in terms of there being some sites available, differ in terms of numbers?
Yes, I think we differ on the numbers, but yes.
Okay, so even if one gets down to just looking within the breadth of 190B to this little issue of alternatives, and you've explained why there are lots of other moving parts to it, but even if one just looks at that, do you say that the evidence indicates an exceptional circumstance, or how do you invite the inspector to approach the evidence on 190B on this issue?
You see, even on that narrow interpretation of the paragraph, I think through the exercise we've demonstrated there's more than adequate scope to develop outside, alternatively to the appeal site and outside of the national landscape.
All right, thank you. Can we look at now 190A, please? So similar, well, happily not quite such a tabular-based exercise, but in terms of 190A, let me just give me 1 second. Yeah. Now, first of all, just some general points. We're looking here at the need for the development, including in terms of national considerations. You've given some evidence about that at the outset, about context, which I won't repeat, but you've explained to the inspector you think that's relevant when you looked at 190A. But it also refers to the impact of permitting it or refusing it upon the local economy. Now, so far as this proposal is concerned, there is some evidence which the appellant produces about impact on the local economy and Mr. Collins' appendices, about the benefits it will produce and so on and so forth. What do you say about that in terms of this issue?
I've given that just limited weight. I mean, the benefits of a construction process are pretty short-lived. And then in terms of the longer-term benefits, well, Hazelmere is a very affluent area already existing. I don't think the appeal scheme is going to particularly change that in any way. So I'd give that certainly very limited weight.
Okay, thank you. In terms of, I mean, put it this way, is there any suggestion that you've seen in evidence that, for example, if this appeal scheme doesn't go ahead, if it's dismissed, that Hazelmere will cease to be a thriving town or anything like that?
No, not at all.
Right, okay. Thank you. Now, again, focusing on the wording of A, what do you say in terms of delivery? There's some evidence for the inspector about delivery. The last inquiry, I think it was agreed that this scheme would not, save perhaps for a few houses, make a material contribution within the 5-year period.
Mm.
Some evidence about that. Looking at what Mr. Collins says now, we'll ask him about it. But what's your position in terms of assuming this gets permission? When actually would it, in all likelihood, on the evidence, produce housing in terms of timing and delivery?
Having consulted with some of the evidence, and I'm thinking particularly of the Lichfield report, start to finish, third edition, and forgive me, I don't have the NID
Right.
number.
Let me just give you that.
It might be helpful to go to that,
Yeah, okay, we'll do that. As soon as I got my
find it.
reference, forgive me. Yeah, so I think you've got it, you're ready.
7.12.
7.12. I think
Yeah.
it's NID 7.12,
NID,
isn't it?
Yes,
Yeah.
thank you.
So that's the third edition.
Yes.
What do you, I mean, again, if you can give the inspector the key references and the key points you'd like him to take from that.
Thank you. I mean, essentially, in trying to draw a bit of a judgment in terms of, well, how soon is this scheme likely to be delivered in full? What's the delivery rates? Now, we're already through the planning process, so the Lichfields document's fairly helpful. So if you go to figure 3.1, I think that's on page 8.
Yep.
And that sets out in the green and the blue Gantt chart. So it sets out in the green, that's the planning approval period, gives a number of years, and it also gives along the bottom axis the size of the site. So this site, you can see the first, if you're looking at that Gantt chart now, the first bar is for sites of 50 to 99 dwellings, the next is 100 to 499. So this site sits pretty much at the lower end of that second bar, so somewhere between the two. Now, if we assume that we're almost through the planning process, because of course we've got an outline, we've got an element of outline on this site, so there is a process ahead of the appellant if the appeal is successful. So they'd have to go through a reserve matters process. There'd be conditions to discharge, the design code that has to be approved as well, and that would be typically in advance of a reserve matters application. Then, of course, you've got going on from that, you've got the delivery period. So you've got the whole site clearance process, and then you've got the construction process. So if you take all of that timeline, put it together, so you're talking about fairly lengthy process. Now, if you in the bracket of 100 to 499, it goes up to 6 years. Now, I don't think it's 6 years, because we're already partly into the planning process, but I certainly think I think it's going to be, I think you'd be going some to get it completed. And let's just be clear as well on this Gantt chart that these timelines are for completion of the first dwelling. So that's just the period to go from once you've got your reserve matters approved, you've had all your pre-commencement conditions discharged, you then start building, and after that, on that second bar, it's at year 6, they're just building their first dwelling.
So, okay, so, all right.
Going beyond that, there's a development process after that, obviously, and the document refers to that process as well. Again, applying the same approach. The sites have, say, roughly 100 dwellings, and it gives it gives a delivery rate of I think for the first bracket, which is the 50 to 99 dwellings, I think gives a bracket of about, I think it's 22 dwellings per annum is the build out rate. And if you go up to the next rung up, if you like, the 100 to the 499, I think it goes up to 60 dwellings per annum. So if you say, well, okay, it's somewhere between the two, it's at the top end of one, the bottom end of the other. I think if you combine those two timelines together, you are looking in terms of delivering the whole site for 111 dwellings, plus getting all the consents, site clearance. It's certainly more than 5 years.
All right, thank you. Now the new, as you've said, the local planning authority is working on a new plan to be adopted by 2028. So assume that's correct. By the time the new plan's adopted, in light of your evidence, will this scheme, even assuming it gets permission, have delivered any material housing by 2028?
No.
Right. Now, good. Now, one of the bits of evidence Mr. Collins has treated us to is Mr. Neam's evidence, which he puts in his appendix, appendix 3. I think Mr. Neam's evidence has itself got its own appendices. Technical report reporting to address para 190 housing need trajectory matters and other matters. Now, I've asked you already about the extent to which that bit of work addressed some of the guidance the government's given on unmet needs and how one assesses objectively assessed needs and so forth. What assistance do you think this bit of work is going to give the inspector in your view?
Well, I think
in relation to 190A.
Yes, thank you. Well, I think obviously there's common ground. The 5-year house land supply, we're at 1.28 years. But what Mr. Neam is doing here, he's assuming that this site will be delivered in 5 years, so it would contribute towards that 5-year housing land supply. I would disagree with that. Spent most of my life working with national house builders, and a site of this size, given the circumstances, I don't believe that would be the case. And I think also what Mr. Neam doesn't do as well, he fails to engage with the latest the development plan process, the ongoing process, and also the national policy on how and where to meet local needs as well. Yeah. So it's a very kind of almost like a policy off approach.
Inspector may have seen an inquiry document, NID 7.28, where it's a comprehensive document from Iceni addressing issues of need and so forth. Have you had a chance to look at that document?
Yes, I have. Thank you.
Just I'll put it this way, I'm not going to ask you about the detail, but does Mr. Neam address the kind of arguments raised in that document by Iceni?
No.
Fine. So when the inspector looks through Mr. Neam's work and his conclusions, which addresses not only the 5-year period, but also does various trajectories for the plan period in terms of the LPP1 plan period, adopts a number of scenarios. Do you think actually that's going to, in your view, assist the inspector or not in terms of 190A?
No, I don't. And I don't think it just doesn't take into account of kind of the wider issues, if you like, once you start looking at those such as we're talking about this afternoon.
All right, thank you. Now, the other point I just want to ask you, Mr. Collins also has Appendix 2 from Tetlow King addressing affordable housing, arguing considerable weight, substantial weight should be given to affordable housing. You address weight, and no issue from the local authority that there is a significant need for more affordable housing in the borough. Now, what do you say in terms of that body of evidence from Tetlow King? Lots of matters are uncontroversial, but what do you say about how the inspector should deal with that evidence?
I think it's well understood that, as it was with the last inquiry, that there is a significant need for affordable housing. and I've attributed my own weight to that need. But it's really made no difference to my overall
Yeah.
conclusion.
Just in terms of giving it some context, if we can just turn up CD 6.1, please, which is the Part 1 local plan again, forgive me. And could you go within that? That's LPP 1. Could you go within that to PDF page 33, and it's in the supporting text to AHN1, and I'm really after para 9.7. Do you have that? It says under, it's in
Yes.
the, it's in the section
do.
dealing with
Yeah.
affordable housing in the district, and
Yes.
taking it quickly, policy context set out 9.7. Can you just tell us what that's
Yes.
discussing, please?
I think this is just really a recognition, isn't it, that the council recognise that the full affordable housing need is not going to be met through the current local plan process.
Yeah, and so there's a realism. The figures are,
Yeah.
as it were, yeah, in that Mr. Teleking relies on, but in reality, that's what the local plan says. Yeah.
Yeah.
The realism. Okay,
Yes.
good. But anyway, it's something you give weight to, the need for affordable housing.
Yes, certainly, yes. Yeah.
All right, thank you very much. Now, anything else you want to say about 190A then, taking it in the round as one of the considerations for exceptional circumstances? Is this something that you think contributes the level of need viewed in context to this being an exceptional case in the context of this development?
To repeat that again, sorry, excuse me.
It was a terribly worded question. What do you say about 190A? It's 5 to 5. Crawling out.
In terms of the need,
How Inspector's got lots of evidence. You've spoken to it. How should he approach that, in your view, as a judgment in the context of whether that assists him in finding exceptional circumstances or not? What's it telling him?
I think there's clearly a need for the development. And yes, it's a national consideration because of its very nature. There is a housing land supply shortfall. But I think in terms of the effect on the local economy, we've dealt with that. I don't think that's really I'd give that certainly very limited weight as part of the balancing exercise. But yes, I would say there is a significant need for housing market and affordable.
Yeah.
But allied with that, there's a substantial need to protect the national landscape.
Yeah, and that leads us to 190C, which requires consideration of any detrimental effect on the environment, the landscape, recreational opportunities, and the extent that to be moderated. Again, you've heard the evidence, you've got your views. What does the evidence indicate to the inspector in relation to that aspect of 190 in your view, please?
Certainly the evidence we heard yesterday from Mr. Petro, which was fairly similar along the lines of Mr. McDermott's last inquiry, and also similar in many respects to the landscape visual impact assessment that supported the original scheme. So we are talking about a very significant adverse effect on the visual and the landscape character. So in terms of C, any detrimental effect on the environment and landscape, there is certainly a very substantial effect.
Yeah, and turn up the previous inspector's decision, please. NID 3.8, his conclusions, 178, towards the end of the decision again. 178, he says their word in his view also be fundamental and serious harm to the AONB, having considered all the benefits of the scheme along with escape for developing elsewhere in some other way, and the consequences of dismissing the appeal, and even were I to reach a finding that the scheme were acceptable in all other respects, in my view, exceptional circumstances have not been demonstrated. Collectively, the benefits of the scheme are not sufficiently compelling to justify the harm that would result, allowing the appeal would not be in the public interest. So, first of all, do you agree with those broad conclusions that that inspector made?
Yes, I do. Yeah.
We'll come on perhaps
Yes.
it may be early tomorrow morning just to finally look at benefits and so forth and the balance. And obviously we've got to take them into account. But looking in the round at 190, do you think the evidence demonstrates there are exceptional circumstances and this is in the public interest or not?
No, the scheme is clearly in conflict.
Thank you. So I've got about, and I'm sorry for going, but I've got about 20, 25 minutes left to go. Now's an appropriate time if you wanted to make, and I'm sorry, I'm slightly over my time estimate, but not by too much, I hope.
It's okay. I'm not very offended. Yeah, if that's a convenient place.
It is, I think. and-
Let's
yeah,
break there. And we'll resume tomorrow at 9:30.
Thank you.
Okay, thanks.
Yes.
Say it, but I knew it.
Yes. No, I'll find out. I don't know whether we can leave stuff.